Court, all rise, please. Yea. All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court in the County of Norfolk. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Thanks, Jeff.
Sure. Judge, this is 22 CR 117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Adam Lally for the
Good
Commonwealth.
morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Tanis Unetti representing Karen Reed.
Good morning, Ms. Unetti. I'm told that David Unetti's held on trial somewhere else.
He is, Your Honor.
Okay. And good morning, Ms. Reed. All right. So first and foremost, housekeeping. Mr. Lally, what is the status of the DNA?
So, Your Honor, the status of the DNA, as I spoke to the lab a few times over the last couple of days, they actually were able to stay late last night and finish the mitochondrial portion in regard to seeing if they were able to generate a profile from the hair sample.
Can you hear him, Ms. Unetti?
I would actually prefer, Your Honor, if you would take the
Or
podium.
just,
Fine.
yeah.
So, Your Honor, just to begin again, so I've spoken to the lab a few times over the last week or so, including this morning. So they were able to stay late last night and finish the generating, to see if they could generate a mitochondrial DNA profile for the hair sample. I was informed this morning that they were able to generate a partial profile. They're still in the process of seeing if a full profile can be generated, but they've begun the process of generating a profile from the sample from Mr. O'Keefe. As far as I'm a little unclear, and I responded with some questions just for clarification purposes, because I'm a little unclear of whether or not a partial profile would be something they could do a comparison with in regard to the mtDNA. And then I'm also inquiring as to, so initially what I've been told is that if they were not able to generate a profile, I would have a report on that by the end of next week, and that would essentially be the end of it. However, given this development, I'm not sure, other than they indicated that any sort of report regarding a comparison would likely be sometime after April 16th. And then obviously I asked for clarification, and I'm still waiting that as far as what after April 16th means, as far as are we talking about, you know, the week following or a month later, or what the situation is. So unfortunately I don't have a ton of clarity, but at least I'm able to tell the court that they were able to generate at least a partial profile from the hair sample.
All right. So trial starts a week from Tuesday.
Mm-hmm.
I would entertain a motion to exclude the DNA. All right. So let's move on to what we
Understood.
have here. All right. So I will hear from the Commonwealth on your motion for a buffer zone. And for restricting clothing.
Thank you, Your Honor. So the Commonwealth would ask that the motion be allowed for a number of different reasons. Essentially, what I would submit to the court is that this is not, as the court is well aware, this is not a novel approach. This is something that's been done in other cases and done specifically in other cases in this courthouse. What the Commonwealth would submit is what's been proposed to the court is an entirely neutral motion, and that it applies equally regardless of viewpoint, regardless of content of signage or clothing items or anything else. The motion the Commonwealth filed is not in essence about any sort of protesters or any sort of presence in regard to them, but more about the jurors and about the jurors' freedom to be free and to come and perform their civic duty free from extraneous influence. We need in this case, obviously, as the court is well aware, a fair and impartial jury. The And this is something that extends beyond just the empanelment of that jury. As the court is well aware, as the court asks questions or inquires of every jury in every case multiple times a day about whether or not that they've been exposed to any sort of extraneous influences, or if they've gone online, or if they've seen things on social media pertaining to the case. And the question I would ask is, how is a juror supposed to truthfully answer that in the negative when they're bombarded with it every single time that they walk in and out of this courthouse? It's not asking for a restriction on free speech or to infringe upon someone's First Amendment right. Protesting is going to happen. That's fine. It's just where it happens and how it impacts the jury in this case is what the Commonwealth has concerns about. Another analogy I would make, Your Honor, is to voting place restrictions, another fundamental right in which there are restrictions as far as signage and footage away from the voting place of how close you can be, that they're not allowed inside the building with signs related to whatever specific candidate you're supporting. You can't go in the voting booth next to somebody, take your candidate sign and shove it in somebody's face while they're trying to exercise their right to vote. Essentially, what this motion is asking is or seeking to protect is the freedom of the jurors who are called upon to execute their civic duty unfettered from extraneous influence. We're not asking the court to restrict the media or anyone's access to the media. And I would note anecdotally that within this courthouse over the last year plus, there have been several instances in which jurors on completely unrelated cases have had to receive instructions from the court and been impacted by the activities related to this case every time that it's on. Lastly, what I would submit to the court is really any opposition, or at least the ones that I've seen as far as an amicus, essentially, the reason for the opposition is because there are parties that want to try and see if they can influence the jury inappropriately in this case. All we're asking for, Your Honor, all the Commonwealth is submitting in whatever form or modifications the court deems appropriate based on the Commonwealth's proposal. But what we're essentially asking for is to allow the jury to execute their duties in this case, both during the impanelment process and throughout the course of the trial as they're hearing evidence, and not be subjected to extraneous influences, regardless of the viewpoint of those extraneous influences during the course of the exercision of that duty. For those reasons, the Commonwealth would ask that the motion be allowed.
All right, thank you. Ms. Unetti?
Thank you. Your Honor, I have three things that I would like to put on the record for this court. First, please note that we do not control these protesters. This has been an organic movement that arose because ordinary citizens were made aware of the case and apparently agree with us that the prosecution of Karen Reed is unjust. Speaking out against injustice is a fundamental American right. My client is appreciative of the support that she has received and continues to receive, but we in no way dictate or instruct anyone to do anything. These are strictly citizens invoking their right to free speech. Second, while we question whether the Commonwealth's motion is constitutional, we are taking no position on this issue. In our view, this is between this honorable court and the general public. It is between.
So, and I share your view. I think this is something that frankly could have been done administratively, but I wanted to give the defendant an opportunity to be heard. So you're not taking a position on it?
No, we believe that this is between the Commonwealth and the Constitution, and in this honorable court and the general public, and that while the ACLU has filed something, members of the public have filed something, they will speak to the constitutionality of this, and other than receiving our sympathy and our blessing, we are not joining in their argument. Again, we're taking no position, and I want to make clear that our position, our intent is and always has been that we are going to win this case inside the courtroom. Your Honor, that is what we're going to do. We're going to win this case inside the courtroom, and with that, I'll waive further argument.
Okay. So I have received something styled a citizen's motion to intervene. And I think criminal counsel surely knows that unlike civil, there is nothing in the mass rules of criminal procedure that supports intervention in a criminal case. But I've read the memo. I received it yesterday and I've read it. I am not going to hear from counsel. I do want to say, and quoting the appeals court, intervention is a concept foreign to criminal procedure. Now, apparently the Civil Liberties Union of Massachusetts, understanding that, filed a motion to file an amicus curiae memorandum. So that motion is allowed. And I have read the ACLU brief, and frankly, I find it very helpful, and I've been persuaded by many of the points in there. So I don't need to hear from anybody, and the ACLU, I think, did a great job in their memo, and I understand their position. So it's undisputed that under our system of government, the people's right to protest is preserved under the First Amendment, as is the free expression of their views. I have to consider, of course, this very important constitutional right, but the bedrock principle of the trial court is assuring a defendant, it is and it must be assuring the defendant a right to a fair trial, which includes a right to a fair and impartial jury, which by definition is a jury free from any outside influence. So my focus has to be on having this jury hear the evidence and the law and decide this case based solely on the evidence and the law that is heard here in this courtroom. I have to balance the rights of protest. The law is very clear on this. Sometimes these are competing interests. But in balancing them, in weighing all the factors, I do find that an external buffer zone is appropriate and that we do need prudent regulation on in-court expression. But the 500 feet is far too excessive. So I recognize that my obligation is that I must reasonably accommodate the rights of all people to protest in a meaningful way, while ensuring, above all here, that this case is decided fairly based on the evidence without any undue interference from outside pressures or influence in accordance with the law. And that's what I will do. So I will have a written order and a very short decision on this by tomorrow, but hopefully by this afternoon. So I will see you all next week. And I intend to go through all the motions in limine on Friday. I would like council to consider how you want to do impanelment. If there is a request for a questionnaire, it needs to be a supplemental questionnaire. Council need to work together. It needs to be one side, one page, two sides, no longer. Council works together, and if you cannot agree on a questionnaire, then part one of the questionnaire will be what you agree to. Part two of the questionnaire will be what the Commonwealth wants and the defendant objects to. And part three will be what the defendant wants and the Commonwealth objects to. And it must all be on one page. So I'll see you all next Friday.
Court will rise, please.